The reproductive health bill has received a lot of backlash with some of the stakeholders saying that the bill is aimed at promoting immorality. Few weeks ago, police in Kakamega County launched investigations against a community health worker accused of administering birth control on 4 girls aged between 14 and 16 years. Although the authenticity of consent of the girls is still unclear, it is alleged that the community health worker took the girls through a guidance and counseling session before the implants were inserted in their arms.
These are young people who are sexually active, who then they went to seek contraceptives from licensed, trained healthcare givers. But access to contraceptives is part and parcel of reproductive health care. Reproductive health care services include access to contraception. So those young people were actually seeking to enforce their right to health.
According to Article 43 of the 2010 Constitution, every person has the right to the highest attainable standard of health, which includes the right to health care services, including reproductive health care. The Constitution has, however, not stated any age limit of access to the healthcare services.
Children, for adolescents who are already engaging in sex, who already have the right information that if we engage in sex, we can get pregnant and we are not ready to take care of pregnancies, it cannot be justifiable in a democratic society to deny those adolescents access to contraceptives, which they have a right to. So that is really the position of the law.
The bill requires the national and county governments to provide contraceptives to adolescents and give them information on the reproductive services.
The Constitution guarantees rights to everyone, children and adults. So there are no special rights for adults, there are no special rights for children. The fundamental rights and freedom belong to everyone.
According to the Center for Reproductive Rights, adolescents should be allowed to access contraceptives to curb teenage pregnancies that lead to maternal death or fatal unsafe abortions.
When services are provided by qualified people in licensed and authorized environment and following the given guidelines, those services will be safe. If services are provided by untrained people in unlicensed services, following regulation, nobody knows, in unknown places, those services will be unsafe. And those are the services that are causing death.
Prior to the 2010 Constitution, abortion in Kenya remained largely criminalized and stigmatized, with the end result being imprisonment of women and medical providers who offered safe abortion. But this narrative changed with the promulgation of the Constitution that now allowed safe abortion on a wide array of circumstances and protection of the trained health workers procuring the abortion.
When we have those prosecutions that are contrary to the Constitution, they are unlawful and they will never lead to any conviction. But they are also a violation of the rights of, one, the healthcare providers, but also the rights of the people, the young people, the women and girls who are seeking reproductive health services.
According to Article 26, Section 4 of the Constitution, every woman has a right to abortion in the opinion of a trained health worker if there is need for emergency treatment or if the life or health of the mother is in danger or if permitted by any other law.
The sexual debut is at 10, 11 years in some areas. It simply means that taking care of that population must start at the earliest age possible with information and also access to the right services.
Notably, though, due to inadequate sensitization of these constitutional rights, law enforcement officers have continued to harass, extort and arrest medical providers even when the circumstances allow a woman to qualify for safe abortion services.
Those kinds of prosecution, they are a violation of the law, and many a times they are an extortion mechanism. The charges are dangled to extort money from reproductive healthcare providers. And that is an issue that the DPP must address.
Ideally, in the case of a pregnant minor, decisions on safe abortion should be after consultation with the minor's parents or guardian, provided that the best interest of the minor shall prevail, which is recognized under Article 53(2) of the Constitution, that a child's best interests are of paramount importance in every matter concerning the child.
We still have massive misinformation, largely driven by those who hold either moral or religious persuasions, which are not constitutional persuasions.
Adolescent boys and girls should be assisted to have sexual reproductive information so that they can fully understand their body changes, with statistics showing that 1 in 5 girls aged between 13 to 19 are sexually active. 10 years after the promulgation of the 2010 Constitution, and the Reproductive Health Bill has seemed to bring more confusion than solution to the stakeholders and the society at large. Jujuna Magundu, K24, Nairobi.